Yeah, that's what I'm talking about.
Yeah,
That's what I'm talking about.
Yeah,
it's fucking metal, mate.
I didn't fall down. Yes.
Good.
I was dancing, so I didn't fall down.
I learned the key is to take my buffer and then Advil half hour before the show, and that way my head banging doesn't give me a headache. So,
if you're not getting a headache or a nosebleed, you're not doing it right.
You're not doing it right. Yep, you're not doing it right.
Jim snuck in here. I see him in the chat.
No, that was me.
Okay. I thought too, so I wasn't sure. Because one was Facebook.
Well, the other, okay, the Discord one, that's
Jim's in a coma. Jim is in a coma, guaranteed.
When I post from here, it there's the link. Well, I don't know, that won't work. I gotta redo that. Okay, hold on. I can try to get. I gotta get the bingo cards.
Yeah, Jim is in a coma, guaranteed.
All I'm saying is, I still demand an ashtray in my green room.
Yeah, sure. We can do that. Okay, there we go. That should work now. There's the link to the bingo cards. What a day! What a day! It's a Karen Reed trial.
Yeah.
Wow.
Lots of feistiness.
Wow, lots of glove wearing and pounding the desk.
Yeah, podium banging. Yep.
Yeah, demand of his trial. Demand of his trial. Only remedy.
Yep.
Yeah.
Good old Alessi.
Apparently, there's some. We found out what really caused the LA riots from Touche. There's controversy in the crochet world. Apparently, hot pink is out of stock. Hot pink is out of stock, and that's what's caused the riots in LA.
Yes. Yep.
Yeah, back orders.
Hold on.
Back orders.
This just in. The cross stitchers versus the cross loopers are battling on the on LA on Hollywood Boulevard outside of the Viper Room.
Yep.
Yes.
Yep.
Needles in hand. Needle fights. Yep.
Yeah.
I thought it was knitters versus crocheters.
Knitters versus crochet. Oh, yeah. Like
I use a loop. I use a loop. My needles are on a loop. Can you crochet on a loop, Touche?
No, the crochet hook has a hook on the end.
Yeah.
Knitting is too straight.
I knit on a loop.
Okay.
Left-handed, by the way.
Oh no!
Left-handed. Oh.
Well, because my mother was left-handed. The only way she could teach me was left-handed.
Oh no, guys! News is coming in. They're burning an effigy that looks like either a very bad cross-stitched version of Phoenix, River Phoenix, or it could be Chili de Castro. I can't tell from the footage. Dr. 5, bring me down a bit lower.
Now,
and Lisa's in with a weird thing. Apparently, hookers win. Hookers.
Yep. Now, I crochet left-handed. I learned from a right-handed lady, so I had to reverse it in my head at 7, and I got it. But I knit right-handed because the yarn store I went to didn't ask me, so I didn't know it was right-handed.
Yeah. I iron left-handed and I knit left-handed because my mother was left-handed. But I write with my right hand.
Okay.
Now at work, nobody likes my desk because everything's on the left. Because I'm left-handed, so my pens, everything's on the left.
Tomatoes. Lane Meyer's next court case is not until July, so it's not over. It's just there's nothing going on.
Now, are we going to cover that trial live like we've been doing with Karen Reed? I don't know.
Yep. Yes.
Oh, we are.
Oh yeah, sure.
Dwayne, start stocking up my liquor cabinet.
Now, hopefully, Karen Reed will be over by then, but you never know. Right now, it looks like it should be in the hands of the jury within the next week or so. The Karen Reed trial. So, well, I don't know if you remember the fine young woman from last Monday's show, who was the Sovset in Kansas, and we played a bit of their live where there was a whole bunch of them egging her on, and she got her window smashed out. She's the one who was crying, "I got it in my shoe, I got it in my shoe."
Best in your shoe than in your hair.
Hey, Karen.
Yes. Hey, Karen!
Hey, Karen.
Well, I have a follow-up to that video because she has made her initial court appearance.
And her boyfriend or husband was stupid because he went with motorcycle also not
Yes.
registered.
Yes.
So both got taken.
Well, he didn't get taken to jail. He got detained at the scene because he was trying to interfere with her stop.
Yeah.
And he was cited and released.
That is
Yeah.
almost as bad as one of the stories we covered on the podcast this week, involving a motorcycle and a fictitious license plate. That read, "Oh, yeah, Florida, never let me down." She was a sheriff's deputy, man.
Well, then I don't blame you. So here we go. This is in front of Judge Hart. Now, do you think she will ask for a lawyer and let the lawyer fight it out for her?
The Macarena, Beanie Babies, and asking for a lawyer as this woman. 3 things people will never ask for.
Okay.
That have been made against me, but I cannot and do not admit to understanding or accepting the jurisdiction.
Next case
comes
state of
from Old
Kansas
Squishy
versus
Gardner.
Sydney Taylor.
Please go over
Leslie,
and give us subscribe if you
25
haven't
CR
already.
250. Good
Yes, Your Honor.
afternoon, Miss Leslie. Miss
Showing the
Leslie, you're
judge your
charged by
boobs is not
way of
going to help your
information
case.
on or about May 21, 2025.
Well, she's at
in
least
Butler
got them
County,
covered.
Kansas,
I'll give
with
her credit for
interference
that.
with law enforcement, a Class
Still
A
though.
non-person misdemeanor. Count 2, same date and
I can
location.
go up in front of the
No
judge. Will
proof
not help
of
your case.
insurance, a
Trust me.
Class
This isn't
B
a what t-shirt contest at
non-person
the
misdemeanor.
PCB.
Same date, location. Count 3, no driver's license in possession, an unclassified non-person misdemeanor. Though, then count 4, same date and location, failure to register vehicle, and unclassified non-person misdemeanor. And Miss Leslie, do you understand the charges pending against you?
I comprehend the alleged charges against me.
Thank you, Miss Leslie. Miss Leslie, you do have the right to counsel if you cannot afford an
Excuse me.
attorney. Pardon me?
Excuse me, I was going to say that I comprehend the certain statutory allegations that have been made against me, but I cannot and do not admit to understanding or accepting
reading
the
the script.
jurisdiction.
Reading the script.
But listen to how the script started. I comprehend the statutory charges against me.
Yep.
Would this be challenging jurisdiction or?
She's coming up to challenging jurisdiction.
Of this court over my person or the subject matter absent proof of corpus delicti and a verified complainant from an injured party. To do so would constitute a waiver of fundamental rights, which I explicitly refuse to waive pursuant to KSA subsection 60-212 in the doctrine of special appearance recognized in Kansas jurisprudence.
Ranch dressing. We need some ranch dressing.
The judge
Okay.
don't care.
You do have
Okay.
the right to counsel if you cannot afford an attorney. One would be appointed to represent you. And Miss Leslie, are you currently employed?
For the record, Your Honor, just to start from the beginning, I, Sydney Taylor Leslie, appearing specially and not generally in propria persona, sui juris, as a living woman and not as a legal fiction or corporate entity. I reserve all rights without prejudice pursuant to KSA subsection 84-1-308 and UCC 1-308. Let the record.
I would like to point out, I have not sped this video up. This is on normal play. This is just how this lady talks. So,
Reflect that my appearance today is under explicit protest and duress and solely for the purpose of challenging jurisdiction and preserving my unalienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And Your Honor, before these proceedings advance further, I must respectfully challenge this court's jurisdiction in toto and move for immediate dismissal of all charges. I hereby invoke the burden shifting doctrine established in State v. Shepard in 2009 and State v. Seams in 2004, which places the affirmative burden upon the prosecution to establish by sworn non-hearsay allegations within the four corners of a valid charging instrument that every element of the alleged offense and my commission thereof has been properly established. The threshold.
He looks amused.
Now, do you think that she understands anything she just said?
No,
No,
absolutely
but
not.
I have a bingo related question. Would
Sure.
free man or free inhabitant cover the fact that she said she is the living woman?
No, because the living man or living woman is a different space.
Okay.
Matter of jurisdiction must be adjudicated prior to any other proceedings. As articulated in Ex parte Young in 1908 and recognized by the Kansas Supreme Court, jurisdiction is the fundamental prerequisite to all jurisdictional proceedings. The legal maxim ex injuria just non autora, law does not arise from injustice, applies to these proceedings in their entirety.
Okay, and the court finds that Miss Leslie is appearing as a sovereign citizen before the court, and the court
Yeah, did you see her eyes get really big? She's about to come unglued here.
once
I
again,
object. I object to any of that derogatory. It's very biased. I move for immediate dismissal on those grounds and
Court
disqualification.
court overrules the motion for dismissal of the case.
On
Court overrules dismissal
this is
of the case.
prejudice and
The court will find that Miss Leslie, that the court does find it has jurisdiction to proceed, and subsequently the court
I
sets your next
object. You
appearance
called me
date.
a sovereign citizen. I object. You called me a sovereign citizen.
Yes, ma'am.
That is prejudice and bias.
No
It-
prejudice
it-
or bias is asserted.
No.
Yep.
Okay, we might as
Oh,
Every time she looks up
Certain
the
statutory allegations that have been made.
thing,
Yeah, she's looking at her boyfriend.
yep,
yeah.
that's what I think.
Yeah.
Yeah.
He's
She
trying
has
to
no idea what she's talking about.
he's trying to help show her when judge says this, you say that.
Yeah.
Right.
Location,
She's a
failure to
lost
register
lamb.
vehicle, and then
Okay. Hey, hit the wrong button.
Standing or
There.
accepting the jurisdiction of this court over my person or
you do have the right to counsel if you cannot afford an attorney. One would be appointed to represent you. And Miss Leslie, are you currently employed?
for the record, Your Honor, just to start from the beginning, I, Sydney Taylor Leslie, my unalienable rights as secured by the Constitution for the United States must be adjudicated prior to
Unalienable
any other
rights.
proceedings. As articulated in Ex parte Young in 19. I move for immediate dismissal on
There
those
we go.
grounds. And
Court
Immediate.
Court
Immediate.
overrules the motion for dismissal of the case.
On
Court overrules dismissal
this is
of the case.
prejudice and
The court will find that Miss Leslie, that the court does find it has jurisdiction to proceed, and subsequently the court
I
sets your next
object. You
appearance
called me a
date.
sovereign citizen. I object. You called me a sovereign citizen.
Yes, ma'am.
That is prejudice and bias. And
No
it
prejudice or
requires
bias
for
is asserted
immediate
as to
dismissal of my
yourself.
case.
However, the court, as opposed to trying to write down docket notes to that effect, is just recognizing what you are advising the court, that the court has no jurisdiction over you, and based on your statement made to the court. Subsequently, the court does find you've posted a $3,000 cash bond. $3,000 cash bond has been made. Court does accept the same, and the court does schedule this matter next before Judge Webster on Monday, August 11, 2025 at 9 a.m. Monday, August 11, 2025, 9 a.m. before Judge Webster. Once again, Monday, August 11, 2025, 9 a.m. before Judge Webster. You do need to participate by Zoom process.
Yeah, I did, because it was brought up. I did want to point out, Biggin, unfortunately was not able to stream tonight due to some technical issues. But please, go over, if you have not subscribed to Biggin's channel, please go over to Biggin's channel and subscribe. And Gia, if you could post a link to his channel, that would be great.
Okay.
At that point. Subsequently, the court finds that Miss Leslie has not requested court-appointed counsel. Court does not appoint counsel at this point. The court does find that she has posted bond in the amount of $3,000 cash, $3,000 cash bond, and the court has scheduled her next appearance date before Judge Webster on Monday, August 11,
Yes,
2025 at 9 a.m.
Webster.
Any other
Regier
matters
is gonna
to come
love this
before the
woman.
court? Mr. Sweeney
No, Your Honor.
and Miss Leslie.
Your Honor, my jurisdictional challenge is predicated upon multiple independent grounds, each sufficient to warrant dismissal. First, I challenge personal jurisdiction pursuant to Kansas Rule of Civil Procedure. I appear specially, not generally, and have not consented to this court's jurisdiction. The record before this court is devoid of evidence establishing proper jurisdiction over my person as a living woman rather than a legal fiction or corporate entity, as distinguished in Hale v. Hinkle in 1906, and recognizing Kansas jurisprudence. Second, I challenge subject.
By the way, I did look up that hateful case that she referred to in 1906. You know what that had to do with?
A goat.
The federal grand juries and what a federal grand jury can and cannot investigate.
Oh, so it's perfect. It's
Yeah,
right on. It's spot on.
Right. Spot on,
Yeah.
and that has nothing to do with what
Yeah.
she's saying.
Spot on. Yep. Federal. There you go.
Well, it also had to do with there was a company that was being investigated by the Federal Trade Commission. The federal grand jury tried to get the treasurer of the company to testify, force the treasurer to testify. The company, so as an agent of the company, subject to litigation, you have Fifth Amendment protection, right? They can't force you to testify. But the federal grand jury was trying to get around this. So this was in 1906, right? So the ruling has to do with whether a federal grand jury can tell somebody whether you have a Fifth Amendment right against self-incrimination, as the subject of litigation. So they're the defendants in a case.
Now, Phil, here's a question.
Yeah.
has any judge asked them, where did you buy your vehicle?
No.
They would have to say a car dealership.
Well, not always. Some of them get them from private sales.
Matter of jurisdiction pursuant to Kansas Rule of Civil Procedure 60-212. B.
And again, you're in criminal court citing the rule for civil procedure, which isn't the same.
1. No verified complainant from any injured party has been filed as required by KSA subsection 22-2301 in Butler County Local Rule 3.1. The perpetrated charges arise from actions of agents of the state acting under a color of law, not from a legitimate controversy between adversarial parties withstanding as required by Article 3 jurisprudential principles adopted by Kansas courts and state ex rel Morrison versus Celebius. Third, I challenge territorial jurisdiction. The alleged incident occurred after I had ceased operating my conveyance and was exercising my unalienable right to travel, placing it outside the territorial jurisdiction of traffic enforcement under KSA subsection 8-244, which by its plain language applies only to licensees who have voluntarily entered the regulatory framework. Fourth, the prosecution cannot establish the corpus delicti of the alleged offenses as held by the Kansas.
Okay, that was a lot of word salad. Think about what she's saying here.
Is she
By
saying
not
she does
having-
not need a license?
She's not, no, what she's saying is, I don't have a license, therefore traffic law doesn't apply to me.
I still
That
say
makes sense. Sorry for the squeaky ball. It's
No, that's
insane
no
here.
problem.
It's
That's no
insane
problem.
here.
I still say that falls under I don't need a license.
I know it does, but I'm just like, one of the things you're charged with is not having a license. Your argument for being charged with not having a license is, I don't have a license, therefore I'm not subject to traffic law.
Brilliant. It's brilliant.
And she mentions the UCC.
It's brilliant.
She hasn't mentioned it yet. She has not mentioned it yet.
The Supreme Court in State v. Stern in 2015, the corpus delicti rule serves as a safeguard against convictions based on false confessions or statements. One cannot interfere with a peace officer absent of.
You aren't charged with making a false confession or statement. So again, spot on with your reference.
Lawful
Spot on.
execution of duties, where the initial detention was unlawful, as it was here due to lack of probable cause, there can be no derivative crime or of interference. Fifth, the refusal to provide identification.
You just see the judge wipe his face like, oh, fuck.
Is not a crime in Kansas, absent specific statutory circumstances not present here today. This is in support by Brown versus Texas in 1979. The Supreme Court held that detaining a
Okay, Brown versus Texas.
Okay.
Brown was in a known high crime area. The officers detained him and requested his identification because he was in a known crime area. So he wasn't charged with anything. They didn't think he committed a crime. He just happened to be in a known crime area. He refused his ID. He was arrested then for interfering with a police officer. It made up the Supreme Court. The Supreme Court ruled the police had no probable cause to ask him for his ID because being in a known crime area isn't illegal and isn't cause for them to ID you. So he was right to refuse the ID because they had no probable cause for the ID. So the idea is if you don't have probable cause, you can't arrest somebody for a failure to obey a police order because it's, again, an unreasonable search. under the Fourth Amendment.
Okay.
That's not the case here. She has an invalid plate. That's what got her pulled over. Ah.
A person solely to obtain identification violates the Fourth Amendment absent reasonable suspicion of criminal activity. The principle has been recognized and applied by Kansas courts. In one moment, please, while I gather another statement.
Oh, during her stop, she claimed the police officer made some comment about having a handbook, and she claimed she didn't have a handbook, but she's got a binder. So she's flipping through her binder, which, by the way, is not a handbook.
Okay, and what another thing is, and this is, may it please the court, for the record, I must now enter an oral objection and motion for disqualification of the presiding judicial officer pursuant to Kansas Rule 2.11 of the Code of Judicial Conduct, as well as controlling principles under the Due Process Clause of the 14th Amendment. During a prior proceeding, specifically this court referred to me by the term sovereign citizen, a pejorative classification which carries with its government manufactured implications of extremism, frivolous, and legal irrelevance. This label, unprovoked and unsupported by any factual predicate, constitutes a stigmatizing judicial characterization that violates my right to a neutral and detached tribunal. The
Phil,
use of that term demonstrates either a prejudiced bias.
Yep.
she says it's irrelevant. Oh, but you're prejudiced. But it's irrelevant. But you're prejudiced.
Right. Right. No Gothic Sparrow, not trained by Chili. However, she is trained by a Subset guru.
Yeah, that's like walking in on your roommate and his girlfriend doing it, and you're like, "We did have an important meeting, but hurry up! But don't go too fast. But we need to talk about this immediately."
Yeah. And let's see, there's something else. A girl named Joe. Yeah, here's what I believe. I believe that they're actually texting each other about what they want to do for lunch, because neither of them look interested in anything she's saying. They're just like, hurry up and get this over with, because you got a court date in August. So you don't care. We're moving on.
Come on. The court cafeteria only has so many Rice Krispie squares.
Or a judicial
She's a stenographer.
predeposition toward delegating the substance of my legal posture. As the Kansas Supreme Court was held, even the appearance of partially mandates recusal, and here the record reflects actual prejudice in open court. Wherefore, I respectfully move this honorable court to dismiss all charges with prejudice for lack of jurisdiction, issue a finding that the prosecution has failed to meet its burden of establishing
Respectfully.
jurisdiction, order the immediate return of all my property seized, including the 251 USD, confiscated and converted to a reloadable Visa card without my consent, order the expungement and permanent sealing of every associated record pursuant to KSA subsection 22-2410, award compensation for the full measure of damages sustained, including costs for my automobile
Compensation.
window repair, bail costs, and compensation for unlawful detention and deprivation of liberty. Grant such and other and further relief as this court deems just and proper. The breaking of my automobile window without warrant or probable cause of a total search of my currency constitutes violations of clearly established rights for which the law provides remedies pursuant to the maxim ubi jus ibi ridium, where there is a right, there is a remedy. I reserve all rights.
Ask her to explain what that actually means. And she can't even pronounce it correctly, so she has no idea what she's talking about. The other thing is, she's asking for damages as if this was a civil court case,
Right,
right?
exactly.
And she's citing the rules of civil procedure.
Right.
None of which apply, right? You would have to sue them for those things if you
Right.
wanted to. They're not going to grant that in a criminal case.
It's without prejudice, waive none,
me
and maintain
money.
my special appearance for the sole purpose of challenging jurisdiction and preserving my alienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And thank you for hearing me. I do appreciate you, Your Honor, and thank you for your time.
And once again, matter is set before Judge Webster on Monday, August 11, 2025, 9 a.m.
Once again, I don't give a shit.
There being nothing further to come before the court. Court is in recess.
Hold on.
And have a good day, Miss Leslie.
Constitutional rights.
Hold on.
Thank you, Your Honor.
She
Okay,
wants
go
her
ahead.
she wants her constitutional rights preserved, but she won't follow the rules that the Constitution and the government put in place.
Right.
Yes. Yes. All of the benefits, none of the responsibility.
Yes.
Yes.
Now, here's a question. Does she pay tax when she buys something? Does she fill out
Well, of course.
paperwork to pay annual taxes? Because that makes her a participant. And that would be a contract.
Well, so during her ride down there, right? She made some statement about now I can't remember. She made some statement about it was costing her time. And the cop said, so you are engaging in commerce.
Remember,
And they came unglued, like they're like, oh, he admits it. He admits he's part of that. And then she's like, yeah, now he's using my terms, not correctly, but he's using my terms. And I'm just like,
remember,
okay.
paying your taxes is just your annual subscription to live in the country you reside in.
So moving on, I have one from Facts and Frauds. Again, please go over and give them a like because they're very nice to share their content.
Actually, we got a motion today, don't we? You got a motion filed?
God, I love this judge.
I do too. I love him. Oakley is my favorite. He is my favorite.
I love that he stands too.
Here,
Yeah.
you don't have to be at the podium, but at least have a seat at that table where that microphone is.
Threats, coercion, and I'm under duress, across.
You're under
Under
duress. How
duress.
are you under duress?
Well, Your Honor, as stated in my motion, there's actually project word that was since been signed by a judge. I have lawsuits filed on all of this stuff right now, which I know that they received.
Hold on, brother. Wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand that. I'll do it. Okay. Just trying to protect myself here.
That's fine. Just make sure you're talking to the microphone.
Absolutely.
Okay.
The judge is trying
All right,
not
you
to
can
say
sit
you dumb F.
Okay. So I think this is your motion to dismiss, right?
Yeah, I have a few in there that I've been repeatedly trying
Okay,
to
well,
be
which one do
dismissed.
you want to start with first?
Well, the recent one I filed, the motion to reject swearing in and all that based off the fact that I said
Objected
I
to
would
swearing
send a
in.
default motion that I don't know how it even got signed past did, but it was never signed or anything. I was also defaulted out the fact that there was a citation that never even presented a court appearance.
Okay, hold
date
on.
and
You're
all
giving me
that
too many issues. You're talking about swearing in, you're talking about a default judgment. Just pick one issue. We're gonna deal with them one at a time. So what do you want to deal with first? You wanna
One of
deal
my
with the
main
default?
motions. Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, don't suppose, it's your motion, brother. Tell me what it is.
Well, it keeps
I
getting
mean,
set
that's the only
aside, so I
civil
have
infraction.
numerous, I have lots of stuff.
Hold on,
going
that's the
here.
only civil infraction I see with your name on it. So I'm just confirming that we're talking
Yeah,
about
it was
that
over there.
charge.
Yeah, sure. It was over
Okay.
there.
So do you know why the default was entered? Did you miss a deadline? Did you
Well,
not?
I was notified, I was called by people that I know within Huron and the police chief stating that I had a missed appearance date I never had an appearance date scheduled, but I went back looking at the citation, there was no date, and actually how fast it got issued raises real concerns to me. And then once I received the default in the order.
Hold on. Let's take one thing at a time. So you said you never got an appearance date.
Correct.
Do you have a copy of the ticket? Because I've got a copy.
Yeah, I
of the
said
ticket.
it's in there. It's attached to my motions.
Okay, do you have a copy
Yes,
of the ticket?
I do.
Okay, then I'm gonna ask you to look at that copy of the ticket. Because my copy of your ticket says contact court for appearance date.
It says contact court for appearance date where it says appearance date on or before, there's nothing.
Okay,
They
but
didn't
it
give me no
says,
time frame.
it says contact court for appearance date. That
How
means the
long?
monkey's on your back to contact us.
I will also on the bottom of the tickets, it says, if you fail to contact court within the specified amount of time, there was no specified amount of time on here. I had no idea when I was supposed to contact court. I was dealing with trying to get my
Well, let
attorney.
me ask you this. Did you contact the court?
I was again, as I said, I had no sort of any time frame
Mr.
to
Crucell,
contact the
Mr.
court.
Crucell, this is gonna go a lot easier on everybody if you just answer the question I asked. I'm gonna give you plenty of chance to give me any argument you want to give. Okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm gonna take that as a no. You didn't
Repost
contact.
the link to the bingo.
So
card.
after 14
Yeah, I'm
days
doing
on
it.
a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that actually when I was defaulted, Your Honor.
Less than that from what?
From whatever this was issued. And like I said, I was contacting.
Well, once
attorneys.
again, I'm gonna draw your attention to the ticket.
Oh,
My
15th
ticket,
brother.
which I think
Thank you
is the
so
same one you
much.
got.
Thank you so much.
Add
Thank
it
you,
to the
15th
program.
band. Great music.
Five connects. $5 towards our goal of banning Coke Dog. Yes.
Yes.
Thank you, brother. Thank you, brother. We'll post a link to 15th Band's channel. If you are looking for some freaking awesome music, 15th is the man. 15th is the man.
And that's 5 loonies, if I'm not mistaken.
Is dated February 3rd.
Correct.
Okay, so that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of a default?
Actually, I received, I'm sorry, I know I got the thing in the mail. When did I get this? This says that, I don't think it specifies a date.
Well, did you make a note when you received it?
This told me, this said I don't remember exactly what date I received this in the
Okay.
mail, but this was scheduled for March 8th.
Okay.
So that was even less than
But what is that that's scheduled?
This says it was for my order, the motion affidavit saying that I was defaulted and saying I needed to pay bond and an a warrant would be issued. And I said,
Okay.
again, that was never.
And that's dated what?
This was dated 3/8. That I needed to appear
Okay.
on or before 3/8.
Okay, so that was March 8th. You were defaulted February 22nd.
Okay. Which then, again, there was no dates. I had no nothing. I had no-
Okay.
no any sort
But once again,
of.
you're not hearing what I'm telling you. The
What'd you
monkey was
put?
on your back. The ticket
Bill?
clearly said you contact us. You never did.
And it also specified.
Yes.
He should have said I'm used to the date being in European style with the month first. It was August 3rd in my head.
Drop it. What are you eating?
Specifies right here. If you
Drop it.
fail to appear by the date specified,
Drop it.
and then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay,
There was no dates.
okay. Do you have anything to add?
I do, Your Honor.
Go ahead.
Mr. Crusoe brought this up when you were the Honorable Judge Martin. She did set aside the default in the civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir, do
aside.
not interrupt the lady. Did she interrupt you?
No,
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Crusoe did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because the Judge Martin set it aside.
So the default's already been set aside.
Yes,
Brother, why'd you just waste 5 minutes of my life?
since March 14th, Your Honor.
which I object to that because there's.
You object to your motion being
No, I
granted?
object to them setting aside my motion. And I
No,
object to.
no, wait, listen. She tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of that.
So you want to argue about the fact that you got what you asked for?
No, what I'm saying is the fact that the due process was violated is what happened in this whole problem. When I was defaulted, due process was violated.
So what? She set it aside.
Not, listen, okay, it was set aside to cause damages to me because of what happened with the default.
Well, explain to me how you were
Damages.
damaged.
First off, there's threats made against me, right? Clearly, he's threatening me to
No,
sue
no, no.
warrants,
I didn't ask you
threatening to
about
pay
threats.
money.
I said, how were you? You said you were damaged. I'm asking you, what was the damage?
But the fact that I was threatened to come in and pay money or warrants. would
How
be
was that
issued for my
damage?
arrest. And I was being threatened by Huron Police, which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money, or I would have been, they'd have been issued.
What money
warrants.
did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside. And Judge Green never said a word to me
Stop.
about any of that.
It's been set aside. Counsel just said, Judge Martin set aside the default. So what that means is procedurally, it's like it's a brand new file. Understood?
Yeah, but that's according, yeah, but that, especially now with the new Chevron overlay, that's just saying that she's just trying to set it aside, that there's no issues.
She didn't try to set it aside, she sat it
But she
aside.
can't. She can't just set my rights aside.
She's not setting your rights aside, she set a default aside because you asked her to.
Well, so if it's set aside, then the money should be returned, correct?
Well, I don't know, did she address the money?
No, she never did. No one did. I
Sir,
extended my motions.
Sir, I'm gonna hold you in contempt the next time you cut her off. The first contempt, $100.
I
The
love
second
this
contempt, a
judge.
day in jail. Are we clear on the ground rules for my courtroom? Is that a yes for the
Yes, Your
record?
Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay, I understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm, the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right? So we started with, what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. So that motion's done. Would you agree?
As long as my money gets returned, then I guess it's taken
At
care of.
some point, trust me, your money will either get applied or returned. Next motion you want to talk about.
The dismissal based off of fundamental violations of my fundamental rights and due process.
Okay, well, tell me more.
Okay.
You have, hold on, let me just cut to the chase. You have more than just the fact that you think you have a right to travel.
Yes, Your Honor. Actually,
That's denied. I'll just cut to the chase. That's denied. I don't buy into that argument. Now, you can appeal that decision to the circuit court. You understand how that works? District court decisions, you can appeal.
absolutely.
Okay, hold on. I denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying, I object to the
You
denying.
can't
of my motion.
object. You can appeal.
Well, I'm just letting you know, I'm saying for the record that I am objecting to your denial of my
Honestly.
opinion.
That's fine.
Okay.
Circuit court
Honestly.
judges have bills to pay too, right? So you appeal me to the circuit court. Do you have any other argument why these cases should be dismissed?
Yes, absolutely. Well, honestly, Your Honor, like I said, I even have lawsuits. They've received my lawsuits to the Huron Township Police Department overall.
Hold on. I don't know anything about lawsuit. How would you suing the township work as a reason to dismiss these charges?
Because the initial traffic stop and everything was an unlawful stop from the get. I was
Okay, but that's got
telling
nothing
you.
to do with your lawsuit. That might be the basis of your lawsuit. So you want to talk about whether or not there was a valid reason for a
Yeah,
stop?
absolutely.
Then make the argument.
Yeah, Your Honor, so prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that are friends, and actually two that are currently working within Huron that had confirmed I had every lawful right to be doing what I was doing. The one even pulled up to me and my wife at a gas station and we were in town, and we are in Sibley and Middlebelt, right near actually where I got pulled over. And we had discussed it and talked about it and went on about our day. And this was all prior to this incident. I had two other interactions with this officer where I specifically told him, I've already been confirmed and doing lawful, I'm well within my lawful rights. I have it documented. You need to go talk to this sergeant that I've been talking to and a couple other buddies, right? I gave him that opportunity. It was shortly after that. And this, I had that confirmation well prior to me even being pulled over. Okay. So then, this officer seen me leaving my house, pulling off my dead end dirt road, proceeded. Like I said, I even told him, I've already had this day. I've already addressed this. You need to go talk to the sergeant.
Right.
Chose not to. Pulled me over, walked up, just started demanding ID and everything from me. He wouldn't identify himself, none of that good stuff. And then now this is where it's all led to. And I informed him, I have body cams, I have my own recording. Like I said, I have a lot.
Okay, but you started out by saying you wanted this dismissed because there was not probable cause for the stop.
Correct.
Okay. And then you went on to tell me how there was obviously a difference of opinion within the department about whether or not what you were doing was legal or not.
Well, I
Is that a
specifically
fair
stated.
summation?
What was that?
Is that a fair summation of what you just said? Some of the officers that you talked to said you could do that, and obviously the officer who wrote you the ticket didn't think you could.
Correct.
Okay, so that's a difference of opinion there, which has very little, if anything, to do with the probable cause for the stop. So I'm going to let the prosecutor explain her position on probable cause.
That's it.
Go ahead.
Thank you, Your Honor. Defendant is requesting this court dismiss the case because of the accusation that operating an ORV on the roadway constitutes a blatant violation of his First Amendment rights and an improper attempt to regulate his constitutional freedom. In his most recent motion, he does accurately cite Terry versus Ohio as controlling. This was plainly a Terry stop.
Well, hold on. His argument is there was no reason for the stop.
He does cite Terry versus Ohio in his newest motion.
Okay.
Terry versus Ohio.
He will admit that the investigatory stop exception in Terry versus Ohio controls the validity of the traffic stop. An officer may stop and briefly detain a person on the basis of a reasonable suspicion that criminal activity is afoot. Defendant claims that he was stopped without legal justification. Rather, defendant was stopped for operating an ORV on the roadway in violation of MCL 324.81122 as adopted by Huron Township ordinance. Pursuant to the United States versus Ferguson, so long as the officer has probable cause to believe that a traffic violation has occurred or was occurring, the resulting stop is not unlawful and does not violate the Fourth Amendment. On authority of state law and township ordinance, a person shall not operate an ORV which is not registered upon a public highway, street, or right of way. On the date and time of the offense, the defendant operated an ORV which was not registered, specifically an ATV on Middlebelt Road, a public highway in Huron Township. Additionally, during the course of the investigatory stop, defendant failed to provide a valid driver's license and failed to immediately disclose that he was a valid CPL holder and carrying a firearm, which is why he was cited.
All right.
Which
So
I object to the.
hold on. All right. So the one misdemeanor is operate the ORV on the roadway, and the other one is fail to display a valid license.
That's
Okay.
correct.
All right. So that's her response to your argument. They didn't have probable cause. What's your reply to her response?
Well, I object to her terms of operate. There's no evidence that I was operating anything.
Okay, let me stop you. I killed that when I said the whole traveling thing doesn't go anywhere with me. Operating and traveling, as you define operating, or as you define traveling, we define it operating. So hold on, I've already ruled on that issue. You can appeal that decision to the circuit court. We're not gonna plow that field again. So now we're talking about probable cause. What I just heard was the township has an ordinance that says nobody can operate an ORV on a roadway. Would you agree that's an ordinance in the township?
Your Honor, I may agree.
Yes or no? Mr.
Yes, I agree with that.
Okay, stop. If that's a valid argument or ordinance, and when I say valid, I don't mean if it's constitutional, if it's, stood the test of a challenge. I mean, if it's on the books, all right? If it's a valid ordinance and the officer sees you doing what that ordinance says you can't do, and he pulls you over, that's plenty of probable cause for the stop.
Yep.
So your motion to dismiss for lack of probable cause is also denied.
Yep.
You need me to clarify that ruling for your appeal reason.
Yes, actually, because Your Honor, I object. to
What
the
do
fact
you
that
Because
not
I'm
there's
dumb.
no
Sir,
RV.
your objections mean shit to me, okay? I don't care what you're objecting to. I don't expect people to like every decision I make. That's why there's an appellate process. So you keep saying, I object. I don't care, all right? It's not helpful for today's process.
Pause it.
My decision to deny your motion to dismiss based.
Yes.
A girl
Oh.
named Joe is asking, who or what is a Coke dog?
Oh, God, don't go there.
Oh, Coke Dog is an annoying character that Jim made up. And he
It
is so
wants
annoying.
to have sex with my Zoe.
Well, he is a Coke Dog. It's not sex. They're supposed to get married. They were supposed to get married. They were gonna elope.
No.
They were gonna elope.
No.
But nobody likes him, and because we do an annual fundraiser, we decided that a good thing to raise money on is to keep him away.
Yes.
And
Well,
so
well-
we're trying to keep him away, and currently he's banned for 976 days which means we only need 119 go to effectuate the ban for 3 years.
Well, to be fair, I did like him until he stole a case of my Vaucluse bitter long necks. Now, that was last week at Gia's birthday party, where for some reason Hank sent him to me in a very large rocket.
Yes.
But
thank you, Jesus.
The fact that he stole a case of my prize beer, I'm in a tiff with him right now.
Yeah. So that's Coke Dog.
On lack of probable cause is because there was probable cause because there was a clear ordinance on the books that the officer thought you were violating. That gives the officer a reason to stop. Do you have any other reasons why you think these matters should be dismissed today?
Gerald and Joe, absolutely no problem. Feel free to ask whatever questions you want to. Depending on the question, we may mock you. But in this particular case, we will not. Jim is not here tonight. That is true. He has Mondays off, and we like to have much fun without him.
Yes, so we do. And the music is better.
Yeah, the opening music, much better. Much better.
Yeah, I don't get criticized for leaving my long neck balls on the ground anymore when he's not here.
Yep, and we don't try to marry you off very often.
We're a twisted bunch. You either get us or you don't. Join us or you don't.
Yep.
Have fun.
Well, we're a fun, lively, motley crew.
Yes,
we are.
Crew from the 80s.
Yes, we are. Yes, we are.
Although Dr. Feelgood could ride around with the pink Cadillac with the license plate as Excalibur anytime.
Yes, absolutely. First off, they're trying to label what
no,
my private
that's
property
Phil
is an ORV.
doing that.
It's not
That's
an
not
ORV.
Jim.
It's not even technically an ORV. If you look up the definition of ORV, it's not an ORV. If you look up the definition of automobile or vehicle or any of that sense, that's what it falls under. It does not fall under an ORV. They're just trying to label it as an ORV is what is happening.
Okay. That seems like that would be an issue for trial for you to testify, maybe me to see some photographs, maybe the officer to testify, and then I'll decide whether or not it meets the definitions of the statutes. Would you agree with me? Because that seems like a triable issue.
I suppose, yes.
Okay, well, this isn't the trial.
Well, I understand.
I don't think it's scheduled for trial. Right, this is just motion. All right. Any other issues that you want to hang your hat on is why it should be dismissed? It being these files.
Like I said, from the beginning, it was like the officer had already been notified 2 times prior to this that what I was doing was lawful, that what I was doing was not an ORV, which I had stated to him.
But that's
witness to that as well.
Purcell, with respect, that's all your opinion. Obviously, the officer had a different opinion about all those things.
Well, right? The officer chose to retaliate against me is what happened, Your Honor. Which I have the evidence and I have witnesses going on.
Or he had a difference of opinion about whether or not you were driving an ORV.
Or just didn't understand the laws.
That could be too. That could be too. But guess who gets to make those decisions? At trial.
Well, honestly, the trial, I'd request a jury trial, which is guaranteed.
Well, you can't get a jury trial on the civil infraction, but you can certainly get a jury trial on the misdemeanors.
Absolutely.
Okay. Do you have anything else to be discussed today on motion day?
Well, yeah, as far as the disclosed CPL, like I said, I have, again, stating I have the body cams and I have my own recording.
But sir, stop. That's going to be an issue at your formal hearing, whether or not you violated that civil infraction. Once again, I got to have evidence, right? I got to take testimony. I'm going to hear from you. I'm going to hear from the officer that wrote the ticket. And then I'm going to decide at formal hearing whether or not what you did was reasonable or not reasonable. But today's just motion day. Today's not the trial. No testimony is being taken.
Oh, I understand that.
Okay. Anything else today?
Well, I guess that's no, but like I said, again, for the record, I do object to moving forward. I do object to anything moving forward from this point.
File your appeal.
No, that's fine. I will.
File your appeal.
I'm going to. That's fine.
Okay. All right. Now, the 200, let's get back to the $280. We'll talk about a jury trial date. Are you going to represent yourself at a jury trial?
Yes, Your Honor.
Good luck. Okay, so was the $280 posted as a bond when the initial default happened?
I believe so. I know.
Do you
that-
have any record of $208? Because we're not getting receipts in the files anymore.
I have the receipt right here, Your Honor.
Okay. I'll return your 280 today. Anything else today? All right, let's talk about a date for jury trial.
September 16th or September 23rd. They're both Mondays.
Maybe 23rd. 8:30? All right, now, Mr. Purcell, I'm going to strongly suggest that you get an attorney involved in this. And we've got court-appointed attorneys, so we'll be happy to talk to you from this standpoint. I'm not taking you to law school on the jury trial day. I'm going to assume and treat you accordingly that you know the rules of the game.
Understand, Your Honor.
You don't.
Oh,
You might say that. You don't understand the rules.
I do.
Okay? How many jury trials have you had?
None, but I have all the evidence.
How many jury trials have you had?
Your Honor, none, but I have all the evidence.
The evidence isn't the rules. There are a lot of procedural rules that will trip you up if you don't know what you're up against.
Yes.
Is talking over everyone, including the judge, and saying, I disagree or I object to everything, knowing how to self-represent.
No, it is not. No, he just proves himself all the time. Yes, a girl named Joe, Judge Simpson says something similar. Almost all judges say something similar because you are at an extreme disadvantage when representing yourself because most pro ses don't know what they're doing.
AKA Lori Vallow.
Yes. Now,
Just
occasionally.
Train crash. Yep.
Got kicked out of court. Representing herself in her own
Train
trial.
crash. Train crash. Yes. Watched it today.
Yes. Just the complete joke. And so there's an old law school axiom that says an attorney who represents himself has a fool for a client. Even attorneys don't represent themselves. You need an advocate for you. So you should always get a judge. And most judges will tell pro ses the exact same thing. You're at a disadvantage. It's just bad. This is about over. I'm going to go. I have another one from Judge Oakley. This one's done. They're just go over the court date. Because I love Judge Oakley. Now, this is a relatively older one, but it's my favorite clip from him because he just like totally schools this dude.
Oh, I
You
remember
interrupt
this
me.
one.
Oh, you just interrupt me. I'm in charge. I get to do shit you don't get to do. It's part of the black role. All right. Appearances for the People versus Frank Mishaw Jr.
Good afternoon, Your Honor. Mohammed Mohammed on the F People PX6771. Nice. What do you have works? Yeah, you.
Oh, and I don't know if the rest of you guys saw this comment. Cicero was complaining about being picked on.
It's not like we said the word.
They fell dead.
Well, what I was thinking is she's crying so much her cheeks are getting moist. Just saying.
Hey.
John Chief to address order. The Bronx.
Yeah. You're a defendant. Sit at the defendant's chair.
I'm sorry.
I wonder if
I miss, try to
sausage
help
have
explain.
Try.
I'll try.
moisture cards.
Mr. Michaud is a sovereign citizen, and though you say not a sovereign citizen.
All right, sir, don't speak.
Maybe I'm not phrasing that.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Michaud's assertion. That there is a difference between the natural version, Mr. Frank Michaud, and those are legal entities.
I don't recognize that.
And that's what I prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me, is it?
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Show that the courts receive objections all the time. The rule objections, they're preserved on the
I'm
record.
thinking about buying a new
He can appeal.
Maserati.
I'll let you build whatever record you want to build, Mr. Shaw.
Are we on record?
Yes.
Are we on oath to the Constitution?
Hold on. Are you picking him up? That's one of the reasons I want you up here, so there's a microphone here.
Oscar, no.
Are you picking him up? Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution?
I didn't swear an oath to the Constitution.
You have
I took an oath that said I would follow the Constitution.
to not uphold the Constitution.
Yes, follow the Constitution.
So you are upholding your oath to the Constitution.
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less. Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today. May
All right, so that's a no. You don't want him to represent you?
No, he's, for the record, he's not my little, I don't have an attorney.
Oh
I
my
present myself.
God.
Yep.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make.
Of course he does.
And that, pending Your Honor's ruling on that jurisdictional issue, I have prepared for to conduct a preliminary exam and could be available if he wanted to ask me to do that at the right time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
Yes, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record. I'm fine.
Okay.
So with that being said,
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine.
so today,
You have a jurisdictional argument you want to make?
what I sir, no,
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
Yes or no?
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do. Yeah.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is this state?
District courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that?
We're under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is
And
it?
it's not common law. It's statutory.
Okay, so it's statutory, that is what, civil?
No.
So what is it?
My jurisdiction is both
I
civil.
can't defend myself unless I have it on. Is it
My jurisdiction.
only two?
Sure, shut up. If you ask me a question, I can't answer while you're talking. My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right, so is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say
All
statute.
right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
I'm an injured party. Who have I injured for the record?
The state of Michigan, and I are bringing the charges.
Am I injured?
Sir, sit down. Sit down. Sit down, or I will hold you in contempt.
Another threat.
You're probably going to hear more than one.
See.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call on the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, would request a mutual order of sequestration with an exception for the OIC.
So again, I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you. So I'm asking you to state your name.
You're with, yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said?
God, I wish there were more judges like this.
Did I object? What am I supposed to do?
I want to know if you understand. You've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of a probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here.
This is the probable cause hearing.
It says.
Sorry, stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds have I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objections.
That we are having a preliminary exam when I haven't had a probable cause hearing and I did not.
They're the same thing.
It's still on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different day that says a preliminary.
Have you ever had a grilled cheese?
It was different.
Have you ever had a grilled cheese?
It was different. Why would it have two?
Have you ever had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, having a court record will reflect at a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud, that probable cause conference has been a misleading made because probable cause conference under the court rules does not require the probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the board to waive his appearance so that he could remain with his family.
Which we did.
I understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are. And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today. Right. So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
All
right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step
Okay, I
being
need to
preliminary
marry
exam.
this man.
At the preliminary exam, the people have to prove to me that there's probable cause to believe that
I
there
am-
was a crime
I
and
am
there's
so
reason to
turned on
believe
right
you were
now.
involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felon. Do you have any questions based on that?
At what point did I waive it? Because if this is a hearing.
You did waive it. There's nothing to
would have a right to have a probable cause conference.
No.
What?
You can do that right now. Do you want to make a deal with people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still takes preparation.
You want a PCC? Go on the hall. Have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? You want to have an exam. And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this day and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to wait? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felon, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today. He ruled on his arguments, and that he preserves his right to.
He can appeal them,
as you've already said. So he wants to sort of move forward on that defense alone. That the waiver does not preclude him from arguing jurisdiction at the circuit court level, but likewise, if he holds the preliminary exam today, holds the people to their burden, he also maintains the right to, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contact.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to.
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested.
Criminal what?
Hold on. I requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is a.
Listen, you can't tell me something and then just disagree with me. Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black roll. Okay? That's just the way it works.
It's called
My
law
courtroom,
school,
I get to
asshole.
decide how it's run. There are no bonds required for me to do what's
Oh,
scheduled
I am
today.
in love.
I know.
I've been doing
need
this
it
25
too.
years. I've never
Are
had
you
a
in
bond.
love, Phil?
I am. Yes.
Yes. Yes.
Okay,
That's
I have a bond.
Everyone
I don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so.
I'm not addressing any of that crap you got in front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have?
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that.
Oh my
I
God.
sent the affidavit of fee schedule for violations
Fee
of my
schedule.
rights.
There are no fee schedules.
Well, I gave you notice, and
Great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
yes, just put it on the record that I served you notice, okay?
Fee
Also,
schedule.
I served you notice on my power of attorney,
Power of
Okay,
attorney.
you said that.
right? And
Move on.
you haven't responded to that, as well as my indemnity bond,
Oh,
which separates me, and I have a private capacity. I am not the artificial person.
I don't
I'm not
recognize
a
any of that.
United States citizen. I am
Stop.
actually.
Hold on. Stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent or you can use or tell me that
not just from what you say, because ignorance of the law is no excuse for you and nobody else. So what you're saying just don't mean nothing. I need to have facts. Okay, well, it does mean prove it. It does. It should mean something because prove it. Please prove. Can I prove what? Prove that I am.
Ignorance of the law.
I am not that I am the artificial person. I can prove you're Frank Michaud. I can prove. Okay, so hold on. You've asked me. I can prove you're Frank Michaud. You know how I can prove that?
Because
when
you're
I called the case and said you either come up here and be Frank Michaud or you leave, you came up here. And
Exactly.
you proved it for me.
What are you doing
threatened
here
me.
if you're not
But if
that
you're not
guy?
you, the threat means nothing.
It doesn't mean nothing. But you still threatening me, and you're using it under color of law.
Okay, listen. At first, listen to me. Mr. Shaw, you have. I've wasted too much time with you. Yes or no? So, sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
There
Yes.
you go.
Should the
If you're
judge
not-
say, let me call your mother and ask her if she gave birth to this dipshit?
I just like I called your name and said, if you weren't here, you're going to go to jail. You came up here.
What are you doing here if you are not this person?
Right.
And
It's
she
so
wants to
stupid.
marry Oakley.
I say it every time.
And then he still wants to argue with them.
But I'm
Like,
not this
well, that
person.
doesn't prove anything. Yes, it does. like, wow.
Yeah.
For contempt of court.
I'm having.
And you can appeal that too.
Yeah.
Sentence is 30 days.
You can appeal. Oh.
I'll see you in 30 days.
Bye-bye. Okay,
Oh.
bye-bye.
From 1 to 30.
Wow. Can't fix stupid. You
I
just
reject
can't.
that. That's
I'm happy to hear your objection.
due process.
Appeal me.
Appeal me.
That's why circuit court judges have jobs.
Yep.
Yeah.
I'll take him out of here. Cut him off. I can give you more than 30 days.
30
You
days.
might want to shut up. Love it.
Or usual practice. The internet is the worst thing in the world for these guys.
Yep. It is. Really is.
That is my all-time
Really, really.
favorite. Judge Oakley.
I am
Yeah.
so grateful. I was raised with none of this shit.
Yes.
You know, none of
Yep.
this bullshit.
Yep.
Just my father telling me the way it was. Yep.
Yeah.
Yep. The truth.
I once, I had a friend. His dad was the head of the public defender's office in my county, and I got pulled over in my girlfriend's car. I was speeding. I knew I was speeding, but she also had her car. The speedometer didn't work. Subsequent, or in between the time I got the ticket and I was going to go to court, we got it fixed. And so I was talking to my buddy's dad, and I said, hey, can I argue this? And he said, well, what was your ticket for? And I said, well, I was going 26 over. And he goes, probably not.
Yep. Yep.
And he goes, traffic laws are what are called strict liability crimes. You either did it or you didn't.
Yep.
Right? There isn't a defense for I did it, but. And he goes, but what you do is, he says, do you have a blue suit? And I said, yeah, I have a blue suit. He goes, do you have a red tie?
Yep. And a white shirt.
And I said, yeah. And he says, your judge is going to be, and you name the judge. And he said, that judge likes guys dressed up in blue suits and red ties. And so what you do is you ask for permission to approach the bench. So grant you permission to approach the bench. You take over your thing and you kind of explain your case to her. And I said, okay.
Can you highlight Seth L?
Sure.
Oh.
I'm sure duct tape is can muffle the sound. Yeah, absolutely. So I did exactly what he said, and she actually knocked it down to a fix-it ticket, and then because it was fixed, it was taken care of.
It's called humility.
Well, But it's also
We've-
called
we've
if I
lost
had
you-
them.
Yeah.
But if I hadn't have known a lawyer, right, who had experience with this judge, who could tell me what to do in order to help myself, I would have just totally blown it.
Yep. Yep.
You have to show up humble.
Yes.
Yes. I might have fucked up. I might have.
Right.
I apologize. I might have.
Yeah.
Yep. Yep. Yep.
So it was one of those things that I just okay. And then you have this guy who just continues to go on and talks himself into contempt charges for 30 days in jail for running his mouth.
Yep. Yep.
Oh, I love Oakley. Love Oakley. And I agree. There need to be more judges like this. Just stop with the horse shit.
Yep. Yep.
Cut through the crap. Well, that's our show for tonight. I'd like to thank
Night,
everybody
everyone.
for coming.
Thanks for joining us.
Yeah, it was a good time. Touche,
Was.
any last words?
That's all, folks.
Yep. Night, everybody. Thanks for coming.
Yep. See you next week. Good night, everybody. Be extra generous to your waitress because Gia picked up your tab.